Under the Sexual Offences Act 2003, consent is a central concept in determining the legality of sexual activity. According to Section 74 of the Act, a person consents if they agree by choice and have the freedom and capacity to make that choice. The Act also introduces the concept of reasonable belief in consent. This means that the accused must genuinely and reasonably believe that the other person consents. Sections 75 and 76 of the Sexual Offences Act 2003 pivotal in defining circumstances where consent is either presumed to be absent or conclusively absent, significantly shaping how sexual offence cases are prosecuted in England and Wales. Section 75 introduces what are known as evidential presumptions about consent. This means that in specific circumstances, it is presumed that the complainant did not consent, and the accused did not reasonably believe that the complainant consented. However, this presumption can be rebutted if the accused provides sufficient evidence to raise an issue regarding consent or reasonable belief in consent. The situations that trigger this presumption include use of violence. The complainant was subjected to violence or the threat of violence, either against themselves or another person, at the time of the act or immediately before it. Unlawful detention. The complainant was unlawfully detained at the time of the act. Unconsciousness. The complainant was asleep or otherwise unconscious during the act. Involuntary substance consumption. The complainant was administered a substance without their consent, impairing their ability to consent. Physical disability. The complainant was physically unable to communicate consent due to a disability. In these situations, the law presumes a lack of consent and absence of a reasonable belief in consent, unless the defendant can produce evidence to the contrary. Section 76 goes further by establishing conclusive presumptions about consent. In these situations, if the prosecution proves that one of the circumstances in this section applies, then it is conclusively presumed that the complainant did not consent, and the accused did not reasonably believe there was consent. The accused cannot rebut this presumption. The two key circumstances are deception as to the nature or purpose of the act. If the defendant deceives the complainant about the nature or purpose of the sexual act, consent is conclusively presumed to be absent. Impersonation. If the defendant intentionally induced the complainant to consent by impersonating someone known personally to the complainant, there is a conclusive presumption of no consent. Sections 75 and 76 of the Sexual Offences Act 2003 create vital legal presumptions that protect victims in cases where consent is compromised by violence, deception, or other coercive circumstances. Section 75 allows rebuttal of the presumption, while Section 76 establishes non-rebuttable scenarios, ensuring robust protection against exploitation and abuse.